You know, there's a few things I'd like to talk about, and maybe there'll be a little bit of jumping around, obviously, but you know, the guilty verdict is why we're here. And you talked about when you filed the charges, why you had filed them and what it meant to the community and why you believed that there was a strong case. And 2 juries agreed with you. You know, as you were delivering those closing arguments, there was a lot of pressure and a lot of eyeballs watching what was happening. What was going through your mind as you were speaking to the jury one final time? What was going through your mind?
You know, I'm not going to say that the pressure and the intensity of it and just the sheer grit required to do 2 trials in a short period of time after 2.5 years of preparation and several hearings, both in these cases and the shooter's case, did not have an impact on me, including heavily scrutinized by every media outlet. However, when you're standing in front of a jury, when I was standing in front of the jury, that last moment I had to address them in rebuttal, the only real pressure and that I feel is the incredible weight and obligation I have on behalf of the 4 parents that were sitting in the courtroom whose children were killed that day. You know, it's about those victims, it's about those kids, and there has been just repeated attempts by all sorts of people, including the defendants and their lawyers, to distract and say that's not what it is about. But it is, because the truth is, one small effort could have saved their lives.
I'm glad you said that, because it makes me think of what I wanted to ask you immediately following the demonstration you gave in rebuttal. Why demonstrate to the jury how to apply a gun lock?
You know, I think there are a lot of lawyers across the country, litigators, prosecutors, some maybe in my office, who would have probably chosen the safer route, which is to not attempt to demonstrate something like that in front of a jury, just in case something might go wrong. But I did that for the same reason I've done everything in this case, and every decision. May not have gotten everything right, but my compass has always been complete transparency and the truth. Whether it makes the case stronger, weaker, it doesn't matter. Whether it makes me look bad, worse, it doesn't matter. The point is, I'm not in law enforcement. I'm not an expert in firearms, but it took me around 10 seconds to apply the cable lock. And I just don't think that there was a way to really communicate that or show that by just explaining it. And I don't think it's as powerful having somebody from law enforcement do it. I'm a mom, and I don't have to, I'm not big in stature. I'm petite, and I don't have a lot of physical strength, and none is needed. In less than 10 seconds, you can pick that gun up and install a cable lock in less than 10 seconds. And I think it's extremely powerful. It was extremely powerful when I tried to do it for the first time in preparation, and how easy it was.
Mm-hmm. You prosecuted Jennifer and James Crumbley. Were you able to, I guess, between the 2 parents, was one case more difficult for you than the other?
Every single thing that has happened since November 30th has been difficult. So the answer to that is no.
Okay. And to know that the family was there every step of the moment. I didn't necessarily see you turn around and look at them constantly, but you knew that they were there, knowing that the 4 families who lost children were sitting there watching every day. What did that mean to you?
You know, there's this perception that what's played out on camera in the courtroom or in pleadings is all that happens. And, there was a lot of discussion about work everybody was doing and the time. But the very first thing Mark Keast and I did when we left the courtroom, after we left the courtroom every single day, was go talk to those 4 parents who were in our comfort room, which we provide so that they have a place to be, and sit down with them and answer all of their questions about what happened that day and explain to them what we could. That's, we didn't rush back to the office and roll up our sleeves and get to work. There was a lot of work to do, but the very first obligation we had was to talk to those parents, and we did that every single day, sometimes twice a day. So the answer to your question is, it was everything. It was everything. That obligation to try to explain sometimes the unexplainable, that's our job. Those are the people that we answer to. Not a jury, not even the judge. We answer to the people who are sitting in that courtroom and who lost their kids, and they are in a situation where things don't quite seem right or fair sometimes, and we have to explain that. What if it were your child? You need somebody. We have victim advocates, but they want to hear from us. And so, I felt a lot of pressure. Mark Keese felt a lot of pressure, and it wasn't because we were worried about our reputations. I'll tell you that much.
In court, talk about the jury for a minute. Sitting in court, I could tell that the jury was visibly moved by the video of the actual mass shooting. Why did you feel you needed to show it in both cases against the parents?
It's a homicide trial. And what happened in that school that day and the way that it was carried out, the shooter's proficiency in weapons, the proficiency in weapons and ammo that were purchased for him by the defendants are absolutely critical and relevant. And, there's no question it's moving. There's no question that it causes people a lot of intense feelings, but that is not a reason not to provide context about the actual crime that took place.
When people look at this case and they say, well, this, I've heard it and I'm sure you've heard it said, experts on TV have constantly talked about how this could change how prosecutions are viewed going forward. But I haven't heard you say every case could end up like this moving forward. You've not said that. Why is that?
You haven't heard me say that, and you haven't heard me say that I think that these prosecutions are a huge moment of policy shift that opens up the floodgates to a lot of other prosecutions. Let me be clear and say what I've said since the beginning. I don't think parents should be responsible for what their children do. I have children. I don't want to be responsible for everything they do. I don't think it sends a message to parents because most parents, most of us do not need that message. Most of us, the majority of us, know that it is not only our obligation, but our absolute privilege and why we're parents to exercise basic ordinary care. Most of us do not need to be told that if you're called to the school and you see, help me, blood everywhere, the world is ending, with a gun drawn that precisely matches the gun that you had just purchased for your troubled son, and you never tell them that you did it, and then when asked to get him help, you just leave. Most of us don't need a message like that. And that's exactly why they were charged, because they did not meet their basic ordinary care that a reasonable person would know, and 4 children died as a result of that. I'm not out here taking a victory lap. There is nothing to celebrate. However, I do think not charging that case would have been a real, it would be completely unjust.
A key witness in your case was ATF agent Brett Brandon, and I thought it was interesting listening to him. At times he was offering his expertise, and when it came to the drawing, he was asked about that. He gave an interesting answer that he believed that was not just a drawing of a sad kid, but did you know that Brett Brandon would testify that that drawing was a prediction of the massacre that was about to unfold?
Well, certainly I know what my witnesses are, hopefully I know what they're going to testify to. In terms of those precise words, no, but I know that it was Brett Brandon and other members of the sheriff's department that day that when these events unfolded like they did and they saw that drawing and they saw text messages, they did what any reasonable person would do, not even law enforcement, and say, something is not right. This is just not right. This set of facts is so outside the bounds of what we see every day and are completely egregious. And, you know, I want to point out that not just one jury agreed with that, two, as well as the Court of Appeals in a published opinion that absolutely completely supported this idea that these are rare facts, and it should be a rare case. You know, and I don't know about other prosecutors, but I can tell you this. We don't need to go looking for more cases to charge. We have plenty that are submitted to us every day, and we're not out looking for parents to charge for what their kids do. But it is also our duty when faced with facts that are so egregious of somebody in their complete gross negligence causing the death of 4 kids that we're gonna do our job.
One of the differences, the striking difference in the cases, deals with the fact that Jennifer Crumbley testified and James did not. How did it change things for you when the shooter's mother took the stand and the shooter's father did not?
You know, you build your case for months and months and months, and you prepare every single thing. But anybody who litigates knows that a trial is a living thing, and it changes quickly. And so we were prepared for anything. We were prepared if one of them took the stand or both or they didn't. The facts remain the same, and we were confident that we could meet our burden.
Okay. In terms of what was the biggest challenge for you, you've been an attorney, you've been a judge. I thought it was interesting in the case against the shooter and the hearing against the shooter that you said you sat in all the different seats in the courtroom. Mm-hmm. What was the biggest challenge for you personally in taking on this case?
Personally, the biggest challenge is, despite the attention and all the hard work and just the sheer volume of hours and dedication, lots of that time spent with victims' families, moms and dads. Even if we succeed, and we did, the hardest part for me is that it doesn't take away anything from these parents. It doesn't make them feel better. We receive justice, they receive justice, but they're still going home without their kids. And so I think for me, you're expected to feel good or successful or joy, and it just doesn't come because they don't feel any better. They just don't.
I'll change gears now and talk about, you want some water?
Yep.
I will. Okay. It's a natural question after something like this. Who else might be charged? Is there any agreement in place with anyone that they will not be prosecuted?
You know, the media reports or anyone reporting that there was some agreement, they're just absolutely false. There was absolutely no protection from prosecution for anyone. And the witnesses who testified were promised nothing and they were given nothing. And I have said to these witnesses the same thing I've said to parents, the same thing I've said to any reporter that asked me. At this moment, given all of the evidence and all of the testimony, I am not considering, nor is there a viable criminal charge against the individuals who testified, or the witnesses for that matter. I do, however, think that there has more needs to be done in accountability, and I stand with the 4 parents in that effort because they really haven't received it. There's a lot the school district has not done. There is even more they haven't disclosed. and they need answers because they want to ultimately prevent what from something like this happening again. And you can't prevent it if you don't really know what happened, or if you have people too concerned with protecting their interests than finding out the truth. But I want to go back to also say that we comply with the court rules and the case law to a T, and we are required to allow the other side information if we promise anything in exchange for anybody's testimony, and we did not. So, a
letter. Sure. The specific thing I'll ask, and I know there's limits to what you can say, but a letter was given to a counselor and a dean of students to say that what they told you would not be used against them, which is a standard letter.
Not exactly. Their attorneys asked for that letter, which is very standard in many, many cases. The difference here is that usually it's not a cooperating witness. They were always cooperating. They never refused to sit down with us. Their lawyers wanted some agreement that what they said in our initial meeting wouldn't be used if we chose to prosecute. But the agreement actually states, and any lawyer who does criminal defense will tell you this, you may be prosecuted. And I stand by that decision because I wanted and needed to understand what those witnesses were going to testify to. They were the witnesses that were there in that meeting that day. And nothing they said was ever inconsistent at all with exactly what they testified to. And in addition, nothing they said was incriminating to them pursuant to, in terms of a criminal charge. And it certainly wasn't exculpatory for the defendants. It wasn't in favor of the defendants at all.
When you're using that term, was that something that you had to share with the defense?
No, we are not required to. The only thing required to give to the defense, and rightly so, I stand by that, I insist that our assistant prosecutors do that, is any agreement we've made with a witness that gives them a plea deal or immunity in exchange for their testimony under oath to prove our case. That was not done. It was not done. I would never do it because I would never do that.
Sure.
If somebody's going to cooperate, they're going to cooperate.
Okay.
But I'm not going to promise them anything, particularly in this case.
I want to talk a little bit about a timeline that involves some threats that were also made public by another outlet. You are aware that there were some threats made by the defendant. It's become known that threats were made by the defendant dating back to 2022. At what point did you make the court aware of that?
It's important to note that we did not bring this to the media. In fact, if we had an intent to do that, we could have just filed a motion about those security concerns. But that's what ultimately these were. My team brought to court security the deputies and the captain in charge of court security and the court as early as February that physical threats were being made by James Crumbley in jail calls against me personally. Lots of other threats about my career and all of that, but also physical threats. And I've shared those with you, and they speak for themselves. And look, I absolutely support what they did. It was brought to the deputies and the court in February. It was then addressed before the first day of trial that morning. It was then addressed based on the court's instruction later the next day, and then later that day. We did not put on the record what it was. But listen, James Crumbley threatened me physically. And he's going to be in a courtroom 3 feet away from me, unshackled and for days. That we have an obligation to protect not just me, but any of the prosecutors in the courtroom and the witnesses and the judge. And
why would I don't think you can answer this, but you have a lot of experience, so maybe some insight. Did James Crumbley know he was being recorded when he made those statements?
Absolutely. He actually said that. He hoped I was listening. He hoped I was listening when he threatened me physically. And
do you think he meant to intimidate you or prevent you from doing your work?
it's important to note that in addition to all the other inaccurate facts, one of which is that they only occurred in 2023, one of the most disturbing threats was January of 24. So that was actually the same month that the first day of trial was set for one of the defendants. So I consider that recent. I would never, ever comment on what James Crumbley thinks or wants or does or doesn't want. I don't care. But I'm not going to let anything stop me from prosecuting and advocating for victims. And I also just think this is a distraction to what we really should be talking about, which is why we don't bring those things out in the open for people to focus on it and media to report on it, because we're here because 2 juries found those 2 defendants guilty as charged, and they did so based on what happened in that school today and their actions and their inactions, which caused 4 kids to be murdered in school. That is why we are here. And that is why we are still going to be here. We're still going to be going into court every day, just like every assistant prosecutor in my office, and do what our job is, and that is to protect victims. And we also are entitled to basic security if there is a threat to that security.
Well said. Was there anything else you wanted to talk about?
No.